Hello, everybody. This is Bruce Morgan, Bruce the Moose with the Bruce Morgan Show. Today, we have a very special video. This is Court of Reality Steve. Now, today is Saturday, but yesterday morning, Reality Steve launched a video where he had two very special guests, Rachel Juarez from Hot Bench and David S. Gingras, attorney for Laura Owens in the Owens v. Eckerd paternity case. Now, Reality Steve here moderated, I don't know if I would call it a debate. Maybe I would call it a discussion. There was no formal, pro versus con position for the debate. There were no fixed time windows for people to make an argument or respond to an argument. So I feel it was more of a discussion than a debate. But I watched the entire thing. It's almost 2.5 hours long. It's over on Reality Steve's channel if you want to go check it out. I watched it and took a lot of notes. So what I want to do is go through my notes, which is, it's not really a recap. It's more my own thoughts on the things that happened and my own commentary, things I wanted to add, talk about whether or not I agreed with a particular argument that someone was making, and just take a look at the discussion and how it went, and then give my thoughts on that. So that's the kind of commentary I wanted to do today. So let's get into it. Now, today, our guest cat in the web browser is Mysterious Cupcake. Mysterious Cupcake has some kind of magic wand. And, I wish I had a magic wand and I could just wave it and make people, pay attention to logic, science, reason, and good arguments. But we're going to see what kind of discussion we can get out of this Reality Steve video. Let's get into it. All right, so we've got Rachel Juarez from Hot Bench, David Gingras, attorney for Miss Owens, and Reality Steve. So we'll start with the introduction. Right off the bat, Gingras claims that his sense of humor is not as good as Dave Neal, which is nice. At least he has a sense of humor. He put Dingus as his name in StreamYard, I guess. I don't know. It was okay. Gingras claims he's a year into the case and he's still figuring out facts from the case that occurred prior to his involvement. Now, for me, if I was a lawyer, and I'm not, but if I was a lawyer and I was taking on a case, I would go do a lot of research into the parts of the case that happened before I joined the case. I would look into related cases. I would look at everything I could possibly look at. So I get the sense that Gingras tries to avoid certain information because then he can maintain this sort of plausible deniability about things and appeal to ignorance. And I don't think that's a good approach. I think trying to look at all of the evidence honestly is the better approach, and burying your head in the sand and not spending time to figure out the facts of the case before the case is over is probably better. Anyway, that's my opinion. Gingras claims people get hung up on little errors and things like this. He gives an example. Somebody was asking him about the third RavGen test coming back in December. He said there was no RavGen test in December. He later admitted that the claim of a third RavGen test in December does exist in pretrial statements. It also exists in Dave Neal videos. And I think the problem here is that rather than just saying, I don't know about that, well, if you think there's a RavGen test in December, prove it or show it to me. He should be the one doing this investigation. He is the attorney. It's not my job to do his attorney research for him. So I think this is very interesting. Anyway, this all happens before Reality Steve has the chance to ask and get answered any questions. And the first question that Reality Steve asks sets off about a 40-minute to an hour-long discussion before they finally come to a conclusion on the answer to the question. So that's what we're going to get into next. So Reality Steve asks why Gingras didn't cross-examine Clayton on June 10th during the hearing. Now, to summarize, his answer is, number one, there wasn't enough time at this hearing. And this is an answer I can agree with because the hearing was fairly short, 2.5 hours. not a lot of time to do direct examination and cross-examination of lots of witnesses, look at evidence, and all of these things in this case. So I agree with that. He also mentions that he didn't think there was enough value for his case in cross-examining Clayton. And I don't know. He tries to make the case that Clayton's not going to tell me anything about whether Laura was pregnant or whether he was the father or not, or to do a determination in terms of ruling on paternity. I don't know if I buy that. When I watched the June 10th hearing, it looked like this guy didn't have very good time management skills. He clearly never had the choice of whether he wanted to cross-examine Clayton or not because he ran out of his time. And so I don't know if he's just doing Monday morning quarterbacking here. I don't know if maybe the problem was if he had cross-examined Clayton, Clayton's answers would not have been good for his case. That's a little bit different than Clayton wasn't able to answer any questions that I needed him to answer. So, I mean, any of these things are possible. I don't know if we'll ever know the answer other than I think we can all agree there wasn't enough time in this hearing. The interesting new information that he brings up here is that he's claiming he didn't invoke the rule of witness exclusion at the start of the hearing because it would have eaten up even more time during the hearing than not invoking it. So if the witnesses are sitting in the courtroom, they can just go up to the stand. It's very quick. If you have a rule of witness exclusion invoked, the witnesses have to wait outside or in a conference room somewhere else, and a bailiff has to walk them in and out, and there's all this time. The clock is still running while all this is happening. So he's trying to save time here, and this is an interesting new explanation. Now, the problem I have with this is when we get to the discussion of Mike Maricini as a witness, I wonder why he didn't invoke the rule of witness exclusion, because it would have solved other problems that he had related to his client and Mike Maricini being in the same courtroom together at the same time, which he wanted to avoid. And he did not use the rule of witness exclusion to solve that problem. And I'm just not sure if that was a good decision or not. Anyway, next, Gingras has an opinion that the June 10th hearing should never have happened. I think this is kind of interesting because it appears maybe he didn't watch the February hearing from before he joined the case. If you go watch the February hearing, it's very clear that there are questions that the judge needs to rule on or resolve. There is a question about attorney's fees in terms of relief. Both sides asked for attorney's fees and relief in the February hearing, not just Clayton's side. So I thought that was interesting. And then, of course, there's a determination of paternity or non-paternity, whether the judge can do that, as well as figuring out what's going on with this pregnancy from a fundamental level. So they spend a bunch of time in this February hearing talking about how they're going to do discovery to get medical records related to this pregnancy, because all they've known up to this point is that at some point she claims she's no longer pregnant at the end of December. We're in February. And finally, at this February hearing, her attorney says, we believe she miscarried. So you need to get all the evidence related to that and look it over and have the judge make a determination on whether that evidence is good or not. So there were clearly multiple things, like at least 3 things that the judge wanted to do that both sides were prepared to proceed with to go do between February and June. So when he says the June 10th hearing shouldn't have happened, I just don't buy it, because if you watch the February hearing, there's clearly things to do. Okay, Gingras sees the case as being moot after Laura claims she is no longer pregnant. He doesn't seem to understand, though, that Clayton is asking for a ruling of non-paternity and a ruling on fees. And also, Miss Owens is asking for a ruling on fees. This all needs to complete. So even without a pregnancy, there's a lot of damage that happened to Clayton because of this case, and they need to resolve it with a ruling of non-paternity so he can move on with his life. Miss Owens saying she's not pregnant anymore is not the same as the judge saying, I don't think she was ever pregnant with Clayton's child. These are 2 different things. So you don't just get one because of the other. So I didn't buy this argument. Gingras appears to also, at one point, this was kind of confusing, he seemed to be conflating the fee issue with the ruling of non-paternity, trying to tie sort of, was there bad faith actions done by the petitioner with the ruling of non-paternity. the bad faith actions by the petitioner was more relevant to the fee remedy determination than anything else. So uh, I really mentally treat these as two separate things that the judge is working on. And the bad faith actions really go to uh, the fee determination a bit more than the ruling of non paternity. If there's no proof presented, like Rabgen DNA tests that prove Clayton's the father, you can have the judge just issue a ruling of non-paternity, even if there are no bad faith actions. So, to me, in my mind, these are two different things, and I'm not sure why he was conflating them here. But of course, a live discussion is always complicated. Gingras argues that a hookup, one or more HCG pregnancy tests, and an inflated abdomen is sufficient for filing the paternity case. He seems to be arguing that people think she shouldn't have filed the paternity case. Okay, and he's saying, well, here are these things that we know. There was a hookup, there was a HCG pregnancy test, there are photos and videos of an inflated abdomen. So you're wrong that she shouldn't have filed the case. But this is a straw man argument because nobody's saying she shouldn't have filed the case. My fundamental problem here is not that she filed a case. It's that after she filed the case, she did not present the correct evidence to back up her claims. And in addition, she committed various bad faith actions like lying on the stand under oath in different cases and faking medical evidence and doing other things like this. It's not about the filing, it's about what happened after the filing, okay? So that's the problem there, right? She filed a case, but then she couldn't prove her claims. She had no proof of clinical pregnancy, no proof of paternity, no consistent OBGYN care, no proof of miscarriage, and, there were no babies in the end either. Okay, so there's nothing. We have what he says. We have a hookup. We have, which, they disagree about what happened in the hookup. We have some HCG pregnancy tests, which are indicators, but not proof of pregnancy. And photos and videos of an inflated abdomen. That's not really proof of anything other than an inflated abdomen. Okay. And of course, at this point, we're still in the first question of why didn't you cross-examine Clayton? And he's going off on his whole theory of the case, basically, which is very strange because, with 2 points, I answered the first question in about a minute. He could have done that, and he's just sort of going off here explaining his whole theory of the case. Anyway, Gingras says Miss Owens almost had a nervous breakdown when attending the June 10th trial because of Mike Maricini's attendance as a witness. He complains about the fact that there was no pretrial conference to review Maricini's attendance and Miss Owens' restraining order against Maricini. I guess he had requested one, but it was rejected, and that's what happens in court. You make motions, and sometimes those motions are denied. That seems like a pretty typical process. Anyway, Rachel Juarez here suggests that another possible explanation for her nervous breakdown was that she thought that Mike might be the person to really prove that her con jobs were, the jig is up, that her actions were all a con, which is an interesting hypothesis. So, they both have their theory of this. Gingras says she almost had a nervous breakdown because she didn't want to be near this person who she claimed abused her. Rachel Juarez says this is the person who can best expose her lies. So, of course, she's going to be nervous. There's really no evidence to prove this one way or the other, but they talked about it for a bit. I'm not sure what to do with it. Gingras complains that Maricini didn't fight Ms. Owens' restraining order and that this is sort of some sort of tacit admission. Or he just doesn't understand why Mike wouldn't fight this restraining order. I think the problem here for me is that the lawyer for Mike Maricini recommended he not fight this restraining order, not that as an admission, but more of a no contest type of position. So you're just saying, look, I don't want to spend the time, energy, money, effort to fight this, so we're not going to. It's not an admission of guilt. And so, that's where we are on that. Gingras claims that because Maricini is a cross-state witness, he has no grounds to be there at the hearing. even under subpoena, he claims the subpoena is invalid. Um, but I don't know that he has good proof of that claim given what happened at the hearing, which we'll get to in a minute here. Gingras claims the hearing was a circus. Now, I was there. We talked to the head of security. Things were very orderly. He said, look, if you want to be in the courtroom, if you want to be in the overflow room, line up right over here at a particular point in time during the day, and we'll get everybody inside in an orderly fashion. If you want to be outside with cameras and photo cameras, video cameras, you can do that. You just cannot go past these concrete pillars at the end of the parking lot, heading towards the doors. And you can park here, you can park there. These parking spots are fine. This is what the extra security is up to. We had really good conversations with the security of the courthouse, and everything proceeded very orderly in a nice fashion. So I don't know why he's saying it was a circus. I think this is just rhetoric. Okay, there's no evidence of this. He also complains that Judge Mata's father was in attendance at the hearing on June 10th. There's certainly no laws against a judge's father attending a public hearing. So I really don't understand why he's complaining about this. He also complains about how the hearing looked and felt to him and his client. My problem with this is that how something looked and felt to you, your feelings about something, your opinions about something, this is not a valid pathway to truth. I'm interested in truth. I'm interested in facts, evidence, science, logic, and reason. You could have felt any number of ways attending a hearing in court. That it's just not interesting to me. It doesn't tell me anything. He spends a lot of time talking about his opinions. He spends a lot of time speculating. He spends a lot of time talking about his feelings or his client's feelings. But I'm just not interested in that. I'm interested in facts. I'm interested in evidence. Okay. And in this discussion, he didn't provide very much. So that was a little disappointing. Gingras then complains that the Mike Maricini laptop forensics falls outside the scope of the paternity case. I disagree with this because the discovery window that was set by the judge at the status conference on February, that went back to August 2020. Okay. 2020 through 2024. So Miss Owens recorded and published a TEDx talk about Mike Maricini with claims against Mike Maricini in 2022. His laptop contained evidence that refuted claims in that TEDx talk. So to me, it's highly relevant, and it's within the window of discovery in terms of refuting a claim that occurred within the window of discovery for this case, in terms of, showing bad faith actions and a pattern of behavior over time from the petitioner. So that's my take on that. Gingras seems to argue that the fees awarded to Clayton were for work unrelated to the case. And primarily, this is in this discussion of this laptop. What I think, this is weird because there was a judgment, right? She was ordered to pay approximately $150,000 in legal fees as a judgment. Now, if you went into that fee determination schedule and took out all the rows related to Woodnick's law firm looking at this Mike Maricini laptop and the reports from the forensic investigator, and you just took all of those out, let's say you cut that $150,000 down to $110,000 or something, like I'm just making up a number here, you reduce the number. Would they then suddenly be okay paying the bill? I don't think so. So to me, this argument is a red herring. It's kind of irrelevant because if you took the fees out that were for work unrelated to the direct case, things related to looking at Greg Gillespie or Mike Maricini, and you just remove those monetary numbers, you'd still have a monetary number. And my take is that they wouldn't want to pay that judgment either. So this is just a red herring. It's irrelevant. Gingras claims he sees a paternity case as very limited in scope. Rachel Juarez claims she sees the paternity case as broader in scope. And this seems to be what happens in a lot of court cases. One side will have a position that they need to try and prove, and the other side will have the opposite position. They will look at case law. They will look at other precedents. They will look at the state law, and they will try to have a narrow interpretation or a broad interpretation, depending upon whether it helps their case or not. And I think in talking to family court experts like Omar, the tilted lawyer, he has repeatedly stated that family court typically has very broad discretion in what they can do compared to civil court. Gingras is more of a civil court background kind of person. So, of course, he's going to argue that the family court scope should be more like civil court, even when that may not be the case. So, I also kind of disagree with him on this as well. Gingras doesn't think issues outside of paternity belong in the case. I think the problem is if you are in an action, okay, anything that can go to show the reason for that action, the motivation, the context of that action is relevant to the case. Okay. In family court, there's a lot of things that happen in life, in families, in personal interactions, history of behavior. These things can all be relative to a case, regardless of, a single scientific DNA paternity case that says, yes, he's the father, no, he's not the father. Maury Povich dances around, whatever. Okay. That's a very narrow part of the case. And I think that family court has much broader discretion to understand what's going on with these families in real life, not just in, is there a positive pregnancy test? Is there a clinical paternity or pregnancy determination through science? I think they can look at both. Okay. Gingras makes an analogy comparing Miss Owen's bad faith behavior with Miss Owens investigating Clayton for bad faith behavior. He sort of creates this analogy as an example. And my problem with this is that in this case, Miss Owens files a case and Clayton is the respondent. So he's responding and he needs to do discovery in order to do his defense or his response. In Mr. Gingras' analogy, he says, what if Miss Owens made another claim, and then because of that claim, she wanted to go investigate Clayton and go off the rails investigating all sorts of things? The problem with this analogy is that in our case, Clayton is investigating because he's the respondent, and Miss Owens made a claim that he was the father. In a correct example, Gingras should have said, what if Clayton made a claim about Miss Owens? Then her response could have been, I need to go do all this discovery and create my defense. So he doesn't even create the correct analogy example here. And of course, this is all live. It's a live discussion. So, but he'll do this again. He'll make analogies or hypothetical situations that just don't make sense. And so we're looking for this pattern. He gives another hypothetical related to the cancer faking evidence from the laptop. This one's kind of interesting. He gives two examples where he argues that the outcome of the case would not be impacted by any of this laptop evidence. Therefore, the laptop is irrelevant to the case. This is the point he's trying to make. But the problem is he only gives two examples in a state space that logically contains four examples. And he talks about two and ignores the other two. And you can kind of see Rachel Juarez, the light bulb's kind of going on, and she kind of knows that he's doing this. And her response, she sort of questions him about this. But I broke it down here. His two examples were, number one, what if she was really pregnant with his twins and she faked cancer? In terms of a paternity case, yeah, if she proved that she was pregnant, and she proved that she was pregnant with Clayton's twins, I don't care whether she faked cancer or not. That's a different matter. So he's correct about that. Number two, his second example. What if she was not pregnant with Clayton's twins, but she didn't fake cancer? Okay, in this case, the cancer faking is irrelevant because she didn't do it. So we're just talking about, whether or not she was pregnant, whether or not the paternity was true or not. So he's correct with these two cases. The problem is he ignores, it's another, I don't know what you'd call it, sin by omission. He ignores the other two cases. The state space, he's got two binary conditions. Accurately being pregnant with Clayton's twins or not, and faking cancer or not. Okay, that means there are 2 to the power of 2 or 4 permutations in this state space, and he ignores the other 2. Why does he do this? I don't know. But anyway, let's go through those. Number 3, one of the other permutations. She was pregnant with Clayton's twins, and she didn't fake cancer. Okay. In this case, the paternity case will be like, okay, she proved she was pregnant. She proved they were the twins. And whether or not she faked cancer is irrelevant. We saw that in the case above, number 1. It's irrelevant. The real interesting one is number 4, okay, where she was not pregnant with Clayton's twins and she faked cancer. This is the case that we think is true, okay? Or at least this is the case we think is provable so far with the evidence we have, right? And here, this is interesting because in this case, the fact that we can show evidence that she faked cancer is relevant because it shows bad acts. And maybe the cancer faking one isn't the one we care about. Maybe it's more about the TEDx talk or something else. Okay. But the bad acts are relevant because, again, the bad acts go to fee determination ruling. Should she pay fees because she committed bad acts during the time frame of discovery in this case? Okay. And also, if there's determination, she couldn't prove pregnancy, she couldn't prove paternity, she did various bad acts. This is what's going to help get you your fee determination ruling, in addition to the non-paternity ruling. So this is the important case out of these 4 permutations, and he kind of ignores this. And you can see Rachel Juarez is trying to get to this case because she knows this is the one that actually happened. Let's talk about what actually happened instead of a bunch of hypotheticals of things that maybe didn't happen. And again, Rachel agrees. She argues this type of historical evidence does impact the bad faith determination, not just the factual determination of pregnancy and or paternity. Gingras complains that he couldn't verify Mike Maricini's laptop. And my problem with this is my understanding is that that laptop was offered to them to do a separate forensic investigator to look at it, and they just declined. So he's complaining about not doing something because he didn't do it. I mean, it's your own fault. You know, get your lifestyle together, get up a few hours earlier in the morning and get more work done. I don't know what to tell you, man. Okay. So, here what he's doing is he doesn't investigate this laptop, and then he gets to say, well, no one knows if the stuff on this laptop is really true or not. Again, this is an appeal to willful ignorance. And it's not as good as actual evidence or doing the actual work. Okay. But that's what he does. Yeah. And willful. And the other problem with this is I think it was either in the pretrial motion or the fee structure document. Woodnick notes that Gingras claimed that the material on the laptop was probably true or likely true. But here he's just like, well, nobody knows if it's true or not. So why does he have one story here in this discussion, but a different story when he's talking to Woodnick Law? This is very suspicious to me. Okay. Rachel Juarez argues that factual determination is separate from fee determination, and fee determination can rely on testimony alone. Gingras disagrees. Gingras wants to see a very strict causal link between fees and bad actions. Rachel Juarez argues that the bad actions only have to exist within the context of the case, and a very strict causal link is not required. And so they, again, at some point here, he just says, well, we disagree. And, when you're having a one-on-one discussion, it's like, okay, you disagree about something, I disagree about something. I think the overarching theme of this type of thing, when he gets to a point where he says, well, you and I just disagree. It's not just you and I, it's him versus basically everyone. If you look at, Rachel Juarez, Reality Steve, everyone that's covering the case, the judges in the case, the judge's superior judge, the appeal judges, the public opinion. Uh, at what point do you get to and you say, well, you and I just disagree, but it's the rest of the world versus me? When do I have the self awareness to say, basically, everybody disagrees with me? Am I doing something? Am I missing something? Am I doing something wrong here? There's sort of this level of hubris that he has to have that is irrational that will just let him say, well, you and I just disagree, but it's with everybody. And I mean, we still have to do the science. We still have to get the evidence. He still could be right because we can't just say he's wrong because everybody disagrees with him. That would be an appeal to popularity fallacy. But in terms of your own motivation in understanding reality, when do you go do that science when everybody disagrees with you? Or do you just put blinders on and say, everyone is wrong and I must be right? It just seems like an incredible amount of hubris to hold this position. And that's the problem I have with it. Okay, let's see. Where are we? We're on to the next section. Let's talk about Mike Maricini. Okay, Gingras claims Maricini wasn't subpoenaed. Rachel Juarez responds and says there was a subpoena. Gingras clarifies and says this wasn't a valid subpoena because it wasn't issued from California. It was in Arizona. Gingras claims Woodnick tells him that Mike is going to testify, but that was not good enough disclosure. I'm not sure what made it not good enough. Gingras claims he was given wrong information about Maricini testifying by Maricini's old California lawyer. I really don't understand why he's talking to Mike's old California lawyer for a case that's unrelated to this case. If Mike is subpoenaed by Woodnick, he needs to talk to Woodnick. So I think he just made errors here in talking to the wrong people. Gingras claims Woodnick provided discovery, Mike Maricini's laptop before the due date. So he admits that, Woodnick told him about Maricini. Woodnick subpoenaed him. Woodnick provided discovery. He just doesn't like any of it. So I don't know what to tell him. Gingras claims he wanted a deposition or an interview and claimed that Maricini's old California lawyer denied him this. He didn't really offer any proof that Mike's old lawyer denied him these things. Also, I don't understand where he thinks Mike's old lawyer had the authority to deny any of these things. It's very strange. In any case, Gingras claims he asked for a hearing and his request was denied. That's how it goes. He claims he wanted a deposition, so why didn't he depose the guy? I just don't know. Maybe he claims he didn't have enough time. Again, fix your lifestyle, get up a few hours earlier, get some more work done. It's on you. You are the attorney. If you want to depose someone, you have to do it. You can't just complain that you don't have enough time to do it. Let's see. Gingras claims he wanted to maintain a 300-foot distance between Laura and Mike. He claims he called the police at Laura's request. He says his opinion is that it was a crime to let Mike be there. My problem with this is that Mike was never arrested by anyone. There were multiple police jurisdictions in attendance at the courthouse. Someone told me at least 3 once the Phoenix police arrived that Gingras called. And none of these police authorities arrested Mike Maricini. If you think someone's doing something illegal and you call the police and the police come and don't arrest someone and leave, then how can you argue that what they were doing was illegal? Like, it's proof by refutation. If what happened there was illegal, someone would have arrested him, right? I mean, it's just very strange. It's a very strange argument. Gingras claims he didn't have time to ask the judge to keep Mike and Laura separated. Why not? There was a pretrial conference in the judge's chambers. there was plenty of time between the time he joined the case and, you know, knew about this Mike Maricini laptop in the June 10th trial. Again, get up earlier and get your work done. I don't know. Gingras claims it was reasonable to call the cops to enforce the court order. Maybe. I don't think the problem was, it wasn't, they were giving him a hard time for calling the cops. And he's saying, look, I had every right to call the cops. I mean, I guess, yeah, I kind of agree with that. The problem isn't really that he called the cops. My problem is that he called the cops and none of the authorities in the courthouse or the Phoenix police that he called arrested Mike Maricini. So he just won't admit he was wrong. He's like, oh, there's this grand conspiracy and the cops aren't arresting people who are committing crime. Like, come on, the evidence is there. Nobody would arrest him. Clearly, it wasn't a crime. You tried, you did a test, and the test failed. And you can't admit it. It's very strange. Gingras claims Maricini was allowed to be there in violation of a court order because Clayton was on a TV show. This is an absurd appeal to rhetoric again. There's no proof of this. There's no evidence of this. He's just speculating and making outrageous statements in order to try to evoke an emotional response. This is not how science works. This is just kind of absurd. Okay, so that's the Mike Maricini section. Let's move on to the next section where they talk more about the appeal. Okay, we're in the appeal section. Gingras says his claim that there was no way in hell he would lose the appeal is a good roast opportunity. Yeah, I mean, I think based on different court cases in Arizona, the numbers I've seen in terms of an appeal being successful in Arizona is, maybe 30%, 20%, 10% on average. Now, of course, individual cases can win or lose. But if you're looking just at the statistics, it's kind of irrational to say that the statistics are weighted against you from the start, but there's no way in hell you're going to lose the case. Gingras doesn't explain why he said that, really. He just sort of redirects and says, maybe we'll win the next appeal. And, Steve says, look, this was not a tactful approach to engaging in the appeal that just happened. Gingras admits that his statements are very similar to political rhetoric, which, we've seen other ones as well. I think he just needs to avoid this. Like, you can't just represent your client and either be her lawyer or be her sort of PR and then just go off and do a bunch of political rhetoric. It's not convincing. Okay, the audience is not dumb, to quote Kendrick Lamar. You need to present facts and evidence, not rhetoric. Rachel Juarez complained about his bombastic language, and Gingras admits he shouldn't have said it. And yeah, it's interesting. I think for me, the interesting thing is when you're looking at these things logically, I remember that video where he said, there's no way in hell we're going to lose. And then at the end of the video, he said, maybe we'll win, maybe we'll lose. Okay. Like, he contradicted himself effectively linguistically in his own video, let alone from that video to this discussion or, post-appeal judgment. I think the problem here is that he's not very disciplined with his language. When you are talking about an opinion, okay, or maybe a desire or an opinion, you should be very careful linguistically to state it as such. I am of the opinion that we can win this appeal. My opinion is that we have a very strong case. I think we have a very strong case. I think we can win. This is a very different statement linguistically than we will win or there's no way in hell we will lose. Linguistically, those are more statements of fact in terms of the way they're perceived by the listener, okay? And if you're making a statement and you are relying on the listener to sort of read your mind or have the correct interpretation of whether you're making a statement of fact or whether you're making a statement of opinion, then you have failed in communication. It's just poor communication. you need to be very clear about whether you're making a statement of fact or whether you're trying to make a statement of opinion or a wish. You know, I hope I get to go out to lunch tomorrow and the soup of the day is French onion. I got my fingers crossed. Be very precise and you will have better communication, better interaction with other people. Okay. That's my take there, guys. Gingras argues that because Rule 26 was introduced, merely introduced, there should have been a safe harbor allowance for Laura to depart from the case. Rachel Juarez disagrees about this. Rachel argues that a fee request occurred prior to the Rule 26 motion introduction, and she is correct. I went back and did a bunch of date checking, guys. This case that we're talking about was filed on 8/1/23. Almost a month later, Clayton filed his original response, and that's the one Rachel Juarez is talking about, where there was a fee request unrelated to Rule 26. It occurred here on 8/21. The Rule 26 motion introduction was on 12/12/23, and we can go look at it. I have this pulled up. So this is after Clayton's original response. This was one of the first filings by Team Woodnick. Ms. Owens then filed to dismiss the case on 12/28. And I have this pulled up as well. We can go look at this. Now, the interesting thing to me is that Gingras keeps talking about this safe harbor allowance. The safe harbor allowance is 10 days. So there's a 10-day window if this safe harbor argument is correct. Now, Rachel, of course, is arguing that the whole thing's not even correct to begin with. But let's give him the benefit of the doubt and say that she should have a 10-day allowance. The problem is this motion to dismiss is 12 business days after the Rule 26 motion is introduced. 15 calendar days. And I don't know if the court uses calendar days or business days, but both of them are more than 10 days. So even if you are willing to give her a 10-day safe harbor allowance, she allowed it to expire. So she failed. And then on top of that, if you aren't willing to accept the argument that the safe harbor allowance should exist in the first place to just throw the case out, then you can't even get to the safe harbor 10 days. But even if you do, she didn't file within the 10 days. Okay? If you go to a page, okay, Justice for Clayton, victimsoflauraowens.com, you can find the court documents and look at them for yourself. And double check that I'm doing the math here correctly. Okay? These are the documents. You can look at the Clayton Eckert documents, and we can see very clearly here, we've got 12/12, defendant's motion for leave to amend response to petition to establish paternity. Okay, I have that pulled up. And then we have 12/28, petitioner's motion to dismiss, petition to establish paternity, legal decision-making, parenting time, and child support with prejudice. 12/28. Okay, and here it is. We see the date up here in the corner, 12/12. And if we scroll down, we can see number 3. Respondent seeks to amend his response, amending the response to include, not replace, but include pertinent background information for this court, request this court sanction petitioner under Rule 26. There it is, Rule 26. Request his reasonable attorney's fees and request this court enter a finding of non-paternity. So we have the two things that we saw in February that we needed to go gather more evidence for or discovery for to get to June. Reasonable attorney's fees, finding of non-paternity. Okay, it's all irrelevant to whether she was pregnant or not in February or whenever, in June, whatever. Okay, so there it is. And again, we saw the date, 12/12. And here's the other document. We've got Alexis Linval, 12/28. Petitioner's motion to dismiss petition to establish paternity. There it is, 12/28. So, do you want 10 days? You had 10 days. They're gone. Sorry. Okay, that's my take on that. Yeah. just to summarize, it seems like she had her 10 days of safe harbor. She let it expire. It only matters if you agree with Gingras' Rule 26 argument in any case, which Rachel Juarez does not agree with. And of course, Judge Mata doesn't agree with it, and Judge Mata's superior doesn't agree with it, and the appeals court does not agree with it. Convince me, but good luck. Gingras argues by citing a case of violation for safe harbor from a case related to Rule 11. So now he's making another analogy by bringing up another case. Rachel Juarez argues that in that case, it's very different because of the additional request for fees in the Eckert case, which we pointed out earlier. Gingras argues that they are structurally the same. I guess he's talking about structural in terms of the process of, going from a Rule 26 motion invocation. Gingras argues that you can't do an end run around the safe harbor. Rachel Juarez argues back that because other requests for fees in the case exist, the cited case isn't relevant. Okay. So Rachel is basically saying, look, there were these other two things we had to do. We had a fees determination. We had a ruling of non-paternity. So even if you throw out or withdraw the Rule 26 motion, there's still things to do. And you can't just dismiss the case. And Gingras says you should be able to dismiss the case within the safe harbor period. Of course, we saw that the 10 days already expired, so it's a little bit irrelevant, in my opinion, but they're arguing it. Gingras and Juarez agree that Rule 26 was filed and later withdrawn. They both agree that there were no sanctions or fees awarded under the Rule 26 motion. So that's nice. Gingras argues that the case should have been dismissed after 12/28. And of course, we disagree with that because as we saw in the February status conference, there were still things to do. Rachel Juarez argues that the case should not have been dismissed because of the other request for fees and a ruling of non-paternity. Very good. Gingras doesn't think unreasonable litigation behavior occurred prior to the Rule 26 motion filing. Ooh, that's a tough one. I don't know how you prove a negative. I think there's plenty of evidence of unreasonable behavior prior to the Rule 26 motion filing. You can go back to the hearings where Clayton was pro se, and I think you can pick out some unreasonable behavior there. Gingras continues to argue that the court shouldn't have continued the case after 12/28. Rachel argues there's no authority given for the Rule 26 safe harbor to completely dismiss the case and all the other requests for fees and non-paternity determination. And I don't think he showed any good evidence that there was authority to just dismiss all these other things once Rule 26 is invoked. And of course, at the end, they just agree to disagree. Steve notes that Rachel and the court and the public all disagree with Gingras, and Gingras can't seem to convince them. And again, this goes back to my earlier argument. At what point are you just sort of all by yourself in an opinion, and literally everybody else has the opposite opinion? When do you start questioning yourself a little bit more? When do you start seeking better evidence? Because if you hold a position and, if it's like you hold a position and you can't convince my friend Nick, okay, fine. Maybe Nick is just unreasonable. But if it's like Nick and Reality Steve and Rachel Juarez and Dave Neal and people in the public and judges, when do you start asking yourself, what's going on here? I don't know. Steve notes that Rachel and the court, we talked about that part already. Okay, so we're on the next page. Gingras argues that when Laura filed to dismiss, that was when Clayton effectively won. This doesn't make any sense. A motion to dismiss is not the same as getting a judge to give you a ruling of non-paternity. So it's not the same. It's not a win. I mean, it's a win in that, it's a win in that the person is sort of saying, look, I'm at the point where I can't make any more progress here with this pregnancy or trying to prove paternity. It's a win from the perspective of, yeah, I don't think they're going to keep fighting anymore. But you have to let the judge finish the case and make rulings on the things that the petitioner and or the respondent have asked for. Gingras argues that Mata had no jurisdiction to do all this. And this goes back to, do you think the family court has broad jurisdiction, broad authority to look at the context of what's going on in a family court case? I think they do. Okay, next section. Where are the babies? Steve tries to get in touch with the timeline. And they figure out May 20th, 2023, this is when Laura and Clayton hook up. There's disagreement about what happened in this hookup, of course. December 28th, 2023 is when Laura claims she is no longer pregnant. So Steve's point here is that this resulted in a 7-month window of litigation and other trouble in Clayton's life. Okay, so Clayton went through a lot of pain for 7 months in this time window. Steve points out that Laura asked a judge if she could show Clayton her 100% pregnant, 24-week stomach in one of the OOP hearings. So basically, Steve says, where are the babies? This is a good question. Gingras doesn't really answer the question at this point in time. He says, well, Clayton should have let the paternity case end, and then Clayton should have gone on to file a defamation case or something else like that in civil court. So he has this opinion that, they should have just used the family court case to talk about, whether Clayton's the father or not. And then once you don't really care whether he's the father or not, because there's not going to be any babies, you just leave. And if he wants to file for defamation or something like that, he should do that separately. And I understand that you can do that. The problem is that you don't have to do that. You can still seek your relief in terms of attorney's fees and a determination or a ruling of non-paternity, because really what Clayton wants is he doesn't want a ruling of defamation. He wants a ruling of non-paternity from a judge. A judge just say, look, you were never the father, because if he doesn't have that, they can dismiss the case, and then Miss Owens can go off to another tabloid or something and say, oh yeah, he got me pregnant, I was pregnant, I miscarried, he was a jerk, and then the case was over. But all my claims are still true. Clayton needs a judge to give him a ruling he can use to defend himself once the case is over in the court of public opinion. And this is what Gingras doesn't understand, in my opinion. Now back to the question of where the heck are these babies? Gingras argues that maybe Laura miscarried prior to filing the case. And again, if we scroll back up to my earlier timeline, the case was filed on 8/1/23. The hookup was May 20th, 2023. So he's claiming somewhere between May and August, June or July maybe, right? There was a miscarriage. Of course, there's no evidence of this miscarriage. So that's a problem for him. Let's see. Gingras argues that Laura's large belly photos and videos are real. I don't know. You have to have a forensic investigator look at the material, the original source material, and the metadata and all that to make a claim about whether a photo or video is real or not. We just don't know. He offers no reason or evidence why he thinks they're real. He just thinks they're real. I mean, he thinks they're real because it's good for his case, I guess. But that's not how you do science. You have to investigate with forensics. Gingras argues that Dr. Medshill said that she could have miscarried in June, she could have had a large abdomen after that, and she could have tested positive for HCG after a miscarriage. The first problem with this is there are a lot of people in the different live chats online that are arguing that, look, if you had a miscarriage in June and it left material in your body that would have resulted in positive HCG tests way past June, like going to November or October, this probably would have resulted in a serious medical emergency, sepsis, or death. So a lot of people don't buy this argument that all of this stuff could have happened. They think the probability is very low. Now, my problem specifically, I'm not a medical expert, so I don't know about sepsis and when you're going to have sepsis and when you're not. My real problem is Gingras is relying on MedChill's argument about this could have happened, that could have happened, the other thing could have happened. I don't really care what could have happened. I care about what did happen. You need to show what did happen to make your case and convince me. And you can't. So that's my fundamental problem with this whole thing in this section, is that you're speculating. It's mere speculation. I'm not interested in speculation. I'm interested in facts. Rachel Juarez, in response to all this, is horrified, rightly so, in my opinion, that Laura claims she was pregnant sometime after the May 20 hookup, but never went to see a doctor until November 14th, which itself was only an HCG test at MomDoc. That's actually not care. That's just an HCG test. She never sought any care for her double high-risk pregnancy. She claims to have epilepsy, which makes her pregnancy high risk. She's claiming to have twins, which makes her pregnancy high risk again. Double high risk. Zero medical care other than HCG tests. I agree with Rachel. This is horrifying. This is criminal negligence if she actually was pregnant, in my opinion. Rachel argues that you don't use a conception date with medical providers. You use last menstrual period, last missed period, whatever it was. Last menstrual period, I think. Gingras appears confused at this. That was interesting. Like, dude, this is your case. You can't be confused by you have to have a timeline. You have to understand these things. You have to have explanations for these anachronisms, like putting a conception date on a medical record instead of the LMP date. You have to be prepared for your case. Rachel points out that this is a double high-risk pregnancy and we have 6 months with no medical care. I think I already said that. Gingras argues that she must not have been planning on keeping the child. And that's why nobody who's going to go get an abortion goes and gets a consistent OBGYN. This is his argument. Rachel Juarez counters this by saying, you don't go get an abortion at or beyond 6 months. Also, we never saw a lot of evidence that she was really planning on getting an abortion. She did a lot of manipulation in terms of communication and saying things like, if you date me, I will get an abortion. Of course, Clayton never said he would date her. So where does Gingras get the idea that she really wanted an abortion? Clayton wasn't doing the thing that she was demanding he do in order for her to get an abortion. She said, if you don't date me, I'm going to have these kids and you're going to be on the hook for all this stuff once I file in family court. This is the threat. This is manipulation. There's no evidence there that she really, really wanted to get an abortion. If she really, really, really wanted to get an abortion, she would have done it back in before filing this paternity case. She wouldn't have had to file this case at all. Back in, what did we call it? When she claimed she miscarried? June and July? She didn't do that. So I don't believe his argument that she wanted to have an abortion. Gingras argues the miscarriage happened earlier than the 6 month window. The problem with that counter argument is that Miss Owens did not know about the miscarriage because she continued on into October and November saying, I'm 100% pregnant. Can I show Clayton my super big pregnant belly? Hey, Reality Steve, I'm pregnant. Hey, Dave Neal, I'm pregnant. She thought she was pregnant. And she didn't seek a abortion at the appropriate time. She didn't know she had a miscarriage. Apparently. There's no proof of miscarriage. So this whole thing is just, this is really where Rachel held Gingras to the fire here. And he just had no good answers for any of this. Rachel points out this problem, right? She didn't know about the miscarriage. And Gingras' response is like, this was all before my time. To me, it's all of these, that was before my time. It's a dereliction of duty. This is just not high quality representation. My lawyer doesn't understand my case. I think I'm in trouble. Oh my gosh, guys. Gingras defers to Dr. Medchill again. He's like, well, I'm just counting on whatever Dr. Medchill said could have happened. Okay, great. Speculation, not facts. And then he claims, I don't know much about this because my wife hasn't had kids. Okay, so he's not a domain expert in pregnancy. Congrats. And he defers to a doctor who never actually saw the patient during the time period when she claimed she was pregnant. Fine. Gingras claims that even if Laura faked pregnancy, she tried to close the case on December 28th. So she should have been allowed to do so. So he's going back to his Rule 26 safe harbor argument because that's the argument he likes. Okay, so he's moving back to that. He argues Clayton would then have been able to sue Laura in civil court. So again, just because someone can do something doesn't mean they have to do it. There's a difference between necessity and sufficiency. And when you write, you get into technical writing, engineering, documentation, these words matter. Necessity versus sufficiency. Okay? Rachel Juarez asks about the request for mediation. Yeah, it's very interesting. Post hoc, in terms of post hoc rationalization, Laura says, well, I wanted to tell Clayton that I wasn't pregnant earlier via mediation. You don't need mediation for, party communication in a court case. So it's very strange to me. It's just not how you do things. Gingras argues that he thinks fee requests should be relative to a period of time during in which the misconduct occurred. And of course, I'm not a lawyer, but everything I've read and talked to other lawyers about, this seems very incorrect because when you're talking about, hey, I have a request for fees for a case, you're talking about the fees over the duration of the entire case. You're integrating fees over from start to finish, not during tiny little time window periods. It's not a la carte. It's for the whole case. So if all of your fees are billed on the final day of the case, you can't say, well, there were no fees up until the final day of the case. You still have a bill with fees on the final day. So the integration doesn't care about the distribution mathematically. So I don't buy this argument that he's trying to piecemeal temporal windows of time so he can win his case. It just doesn't make sense to me. But again, I'm not a lawyer, but that's my take. All right, let's go on to the next section. They talk a bunch about Judge Mata. Okay, Gingras cites a case where the judge admitted to extrajudicial research. Rachel Juarez argues that in this case, there was no admittance of extrajudicial research. Yeah, so they're not the same. Gingras then pivots and goes to a different case where the judge took somebody's social security ID, went back to chambers, came back, and then noted that the person had a police record. So he's assuming that the person used this social security ID to do extrajudicial research to find a police record. And, maybe they did, maybe they didn't. We don't know where this information about the police record came from. It's just suspicious that the judge asked for the social security ID. Okay. Now, Rachel's counterargument to this is that case created structural error because the judge failed to recuse themselves. I guess the judge was required to recuse themselves for some other reason. And the judge failed to recuse themselves. So it's a recusal problem, which is structural error. In our case, the Owens v. Eckerd case, Judge Mata was never required to recuse herself. Okay, they filed a motion to change judge, but that was denied by the superior judge. So there was never a requirement to recuse. So again, Rachel Juarez does a great job of pointing out how these cited cases have no relevance to our case. Rachel further argues that the Planned Parenthood being closed on Sunday issue is not grounds for recusal. Gingras speculates about where the info came from. Again, speculation. I don't care about speculation. I care about facts. Gingras is basically ignoring that the correct answer for where did this info come from is I don't know. None of us know. We don't know. The judge never said where this information came from, so nobody knows. The intellectually honest answer is I don't know. Speculation is not an intellectually honest answer. And it's not a good basis for filing an appeal or doing all these things. Rachel puts forth other alternatives to try to then extrajudicial misconduct to say, look, you're speculating on the thing that's good for your case. What about all these other things that could have happened? And Gingras just sort of ignores all that. He deflects by going back to discussing the recusal case that he cited. But of course, again, in that case, there was a recusal requirement. In this Owens v. Eckerd case, there's no recusal requirement. Gingras moves on and brings up that Mata's dad was there. Again, it's not illegal for a judge's father to attend a public hearing. Gingras complains about Mata setting up an overflow room. For example, how did she know an overflow room would be needed unless she's following the case and knows it has a lot of popularity? He completely ignores other alternatives. This is called an argument from incredulity. He can't accept any other explanation for the Planned Parenthood closed on Sunday information, for the overflow room. He can't accept any alternate explanation that would be bad for his client. He only wants to accept the ones that are good for his client, and he's incredulous about anything else. This is a fallacy called the argument from incredulity, okay? He can't accept the idea that maybe the courtroom administrator person, the guy that helped with audio and video setup, could have talked to somebody like Lauren Knighty or Megan Fox prior to the hearing and came to the understanding that this case would need an overflow room. He can't accept other potential explanations. And he also can't say, I don't know, unless it suits his case. Okay. Gingras assumes Mata did extrajudicial research because he can't seem to fathom a different potential answer, including the correct answer, I don't know. We talked about how this is an argument from incredulity. Rachel Juarez argues that the Social Security ID case was about information that would have been inadmissible in the case. If the Planned Parenthood being closed on Sunday information had come through Dr. Dean's report, it would have been admissible. So, I don't know. This is not inadmissible information about whether something is open on a particular day or not. So again, the cases are different. The information is different. All right, so that's interesting. Gingras complains about Mata ruling against him across multiple motions. And of course, his conclusion or his feeling, again, he's going back to his feelings. This is not evidence. His feeling is that this is bias, it's prejudicial, it's not normal. Maybe he's just doing a bad job, and that's why he's losing his rulings. Maybe his client doesn't have a good case. Maybe he's a great lawyer, and his client just doesn't have a good case, and that's why he's losing his rulings. I mean, incredulity and your feelings are not going to convince me, sir. Rachel argues that family court frequently tries to move things along, and this may be why a lot of motions are getting dismissed, because they just want to keep things moving. And of course, this is not an attribute that's similar to other court domains outside of family law. Again, I don't think family law is Gingras' primary domain. Gingras argues that it's his feeling. And again, feelings are not a valid pathway to truth. I can't use it to get to an answer. Because you could have a feeling, somebody else could have the opposite feeling. I don't know how to reconcile that. Gingras complains about Woodnick not talking to him. This is interesting because the fee structure document appears to have numerous cited interactions between these guys. So I don't know exactly what he's talking about there, because there is evidence of interaction. Gingras claims there are Clayton supporters who agree with him about his position on Judge Mata. So that's interesting. The problem with this is he offers no quotes. He doesn't offer any screenshots. He doesn't offer any evidence of this claim. He doesn't explain why they agree with him. That's the important part. We don't know if what they're saying, is he interpreting what they're saying as, oh, this person agrees with me? Is he taking their comment out of context? Maybe it's legitimate and they do agree with him. We just don't know because we can't see the evidence. So this is just undisciplined arguing because you're not showing your evidence. It's an example, the show don't tell example. He's telling us that there are people that agree with him. He's not showing us that there are people that agree with him. So it's a weak argument. Gingras hypothesizes that Mata was online looking at who knows what. Again, speculation, a hypothesis. He claims he doesn't know for sure and he hasn't deposed her. Okay. So you don't know. It's speculation. What do I do with that? I can't do anything with it. Gingras brings up the roving room review of Judge Mata related to a case involving a snake. This was a negative review. This is interesting. He says he reached out to the reviewer and didn't get a response. And of course, he didn't get a response. So Reality Steve says, what if this review is just, garbage or it's fake or trolling? Gingras says, what if it's true? I mean, they're at this impasse because they're just like, we have claims. In order to prove your claim, you have to go out and get the evidence that will convince other people of your claim. You can't just sit here and say, like, what if it's true? Gingras argues that it sounds true to him. Again, we're going back to feelings and emotion. Doesn't work. Rachel argues that the roving room is not very useful because every judge out there is going to get a bad review from some disgruntled litigant because the job of a judge is to rule in favor of one party versus another. So there will always be someone who's losing, who's going to be bitter and might, write a bad review and exaggerate what happened and just be angry, right? I think Steve called it was it Yelp for judges or something? It's probably worse than that though, because a restaurant gets lots of customers. I don't know that judges have a statistically significant amount of customers or litigants compared to a restaurant that's been around for a long time. I don't know. So I don't think this roving room thing is very valuable. I don't think it's a good argument. Here's a judge who has one bad review. So what? Doesn't mean the judge was biased in your case. There's no causal link. Okay, let's move on to the next section. Let's talk about money. Show me the money. Reality Steve asks about the Trump comparison that Gingras made in his previous video. And in this comparison, I think Gingras' example was another example of a broken hypothetical. If you go back and watch his video, he talks about Trump not paying someone and then that person being very depressed and maybe committing some self-harm. And then he says, but you, Laura, you won't hurt yourself. So it's weird because linguistically, it's like he's trying to frame Clayton as being analogous to Trump and Laura being analogous to the person who was owed money. But in this case, Laura owes Clayton money. Laura is analogous to Trump and Clayton is analogous to the person who was depressed and committed self-harm. So he has it backwards again. His examples, his hypotheticals are just broken. I don't know what to do with it. It doesn't make any sense. DSU moves on. Gingras moves on. He argues that Laura functionally can't pay the bill. Like she doesn't have any money. Reality Steve then gets a little confused, I think. He asks about where the money is from the court hearing procedure and says, wasn't there $200,000 in a bank account? And I think he's confused because there was a bank account statement that Laura used to show Clayton she could purchase properties, and it had about $450,000 in that bank account. And then later, for the case, she testified that her annual income split with her mom was, or shared with her mom, was $200,000 a year. And so I think Steve thinks that the $200,000 is in the bank account or something. And this is kind of bad because Gingras basically just says the 200K, he focuses on that. Nobody ever brings up the 450K. So Gingras doesn't have to explain where the 450K went, and he doesn't. And my question is, where's that money? If she's broke, where did that money go? Or was that original document that showed $450,000 in a checking account, was it fraudulent? These are the only two options I can hypothesize. The 450K either never existed from the start, or it disappeared between the time that statement was shown to Clayton and today. Where did it disappear to? This is the question we didn't get an answer to, because Gingras argues that the 200K per year income is no longer valid. He argues this because he says the Owens v. Eckert case notoriety has ruined this $200,000 a year income because there are no more podcast sponsors for their podcast. To me, this doesn't make sense for a variety of reasons. The first reason, this podcast, if you go look at all the episodes, they don't have any fresh episodes since like January of 2021. Okay, this is well before the case was filed. So how has this case stopped them from making new podcast episodes if the podcast didn't produce new episodes once the family moved from California to Arizona? Of course, you're not going to have podcast sponsors if you just recycle podcast episodes. What they do is they take their episodes, re-upload them with a new title, and it's just like, okay, refreshing it, which is fine, but I don't think you're going to make a lot more money just recycling old episodes. And of course, that has nothing to do with this case. So I don't believe his explanation here. The other reason I don't think this makes any sense is that a lot of people who've looked at these financials say that the majority of her income should be coming from this horse business, not this podcast business. DSG never brings up this horse business at all. So we have no information about it. So where is the money? Again, he's omitting things like the 450K bank account, the horse business. He's omitting these things so that he doesn't have to talk about them. Gingras then says he's seen a bank account with no money in it or hardly any money, and Laura's very poor because of this. I don't buy this argument either, because I can show you one bank account that I have that has $100 in it. Is my net worth $100? No, that's just one account. He hasn't done a financial deep dive on all of her finances. He's like, oh, I saw a bank account and it had a small amount of money in it. She must be poor. This is a terrible argument. This is not grounded in mathematics or evaluating evidence or doing financial analysis. It's just a poor argument. I find it unreasonable. Okay. Gingras then explains he's not encouraging Laura not to pay. He's saying she can't pay. And my problem with this is if you go back and watch his video from before, he makes these statements like, I hope you never pay Clayton. That's not the same as saying, I understand you can't pay Clayton. Now, maybe when he said that, he meant, I understand you can't pay him, so I hope you never have to. I mean, it's just, again, it goes back to the discipline in word choice and how we communicate and how we can communicate more clearly. People don't trust you because in your old video, you said, I hope you don't ever pay Clayton. But in this new video from yesterday, you say, she fundamentally, physically can't pay Clayton, and that's all I mean. It's because as a listener, it appears you said one thing on one day and a different thing on another day. And when you do this, you erode trust. Trust is hard to earn. It's easy to lose. It's easy to lose when you make two statements that can be seen as contradictory or different and then claim they're the same. So do better at communicating clearly. Gingras argues that bankruptcy would stop Clayton from being able to collect his judgment. My understanding is that some judgments are immune to this bankruptcy claim and you can still collect your judgment. The problem here is I don't know if the one we're dealing with here is one or the other. I just don't know. I think we would need to consult with a bankruptcy specific accountant, a bankruptcy specific attorney in order to try and assess whether this judgment is, uh, you know, immune to bankruptcy or not. In any case, Gingras then says that Laura doesn't want to file bankruptcy anyway, which is interesting. And I'm not sure we really got a great answer about why. In any case, the discussion moves on to a new topic. In this topic, Steve and Rachel talk to David about working for free. Gingras argues that he's working on the appeals for free because Laura was treated unfairly. So he's trying to help someone who was treated unfairly. My response to this is I just can't believe he thinks she was treated unfairly. Look at what she did during this case. I made a list. We're going to go through the list. Get ready. She went to The Sun, which was a tabloid, and she talked about this scandal in the public domain before Clayton talked about it in the public domain. She argued and lost a bunch of arguments with Reddit about this case in the public domain. She went out and got some of Clayton's speaking engagements canceled, so he lost money. That's effectively a good cause for defamation right there, by the way. She faked ultrasounds. She got a fraudulent order of protection based on a meme that she says Clayton made that he did not make. She failed to prove clinical pregnancy in court. She failed to prove paternity in court. She failed to obtain consistent medical care for a double high-risk twin pregnancy. She failed to prove miscarriage. She failed to obtain legal ultrasounds, legit ultrasounds, I should say, or fetal heartbeat monitoring that would prove pregnancy. She faked medical records, sent them to Dave Neal and Clayton. She sued Dave Neal for harassment and then dropped the case when it was clear it was never going to go anywhere. It was just to burden Dave with a court case and legal fees. She pretended to be Tag and Chase J. Jones, different troll personalities, based on Google two-factor authentication with her own phone number. If she was Chase J. Jones, then she committed mail fraud because she filed motions from a Seattle P.O. box to Los Angeles court in the Dave Neal case. She sent harassing emails and texts to Clayton. She lied under oath about various different subjects, like seeing a doctor last Friday, and then later saying, no, I made and canceled that appointment. About which Planned Parenthood she alleged to have gone to. She did all of these things, and you're saying she was treated unfairly. There was a judgment by Judge Mata. The judgment was upheld by Judge Fisk. The judgment was upheld by 3 appeals court judges in Tucson in a different domain. How is anything here unfair? Doesn't make any sense. I'm unconvinced. Let's go on to the next section. So Rachel brings up Laura's past behavior towards Mike and Greg, relationships prior to the Clayton Eckerd relationships. Rachel argues that there are more worthy people to work for if you're going to work for free. So, they're still talking about working for free. And they're saying, look, this person that you're representing has bad behavior. There's probably more worthy people if you're going to work for free to donate your time to. And I mean, I don't know. To me, this is a bit of the fallacy of relative privation, because just because there's somebody out there who's maybe worthy of free representation doesn't mean that someone else who's maybe less worthy shouldn't get some free representation also. Like you can't just sort of globally prioritize everything in the universe and only do the top priority things. You have to sort of act more locally. Like, I can get involved in local politics here in Oregon. I can't worry about, you know, maybe there's a worthy issue that's more important in Illinois, but I don't live in Illinois. Like, you can't, you have to prioritize at some point. So I don't know. I don't think this is the strongest argument from Steve and Rachel. Gingras argues that Laura is his friend, so he's helping her. I think this is a little creepy. I mean, he's supposed to be her lawyer. He's supposed to be a professional. Why are they friends? I don't know. I don't know if I would recommend a lawyer represent their friend. I think maybe they should get somebody who's a little bit more impartial so they can have a professional relationship instead of a personal relationship. So this is a little bit of a red flag. Gingras argues that in his interactions with Laura, she's just a normal person and there's no red flags. Yeah, I can understand this. I mean, I think, there's a range here of behaviors that people exhibit depending upon the context in which they're operating. So there's, anecdotes about when the pandemic started, and, a lady might say, oh gosh, I got to see my boyfriend call into work calls at home, and his personality, he's very, strict or uptight when he's talking to people on the phone, but then he's really laid back when he's with me, So he has a work personality and a home personality, okay? And that's kind of a mild example, okay, of people behaving differently depending on the context they're in, okay? If I'm talking to somebody I'm dating, I might behave differently than when I talk to somebody I have a business relationship with. A more extreme example, I recently watched the documentary on Netflix of the Long Island serial killer that they caught. And it was very clear that he had a very different personality when he was picking up sex workers and murdering them versus at his job in Manhattan, where he had an architectural firm and he was talking to people and doing YouTube interviews and marketing and all of this. It's almost like there's two completely different people there. So the fact that she acts one way when she's talking to her lawyer doesn't tell me at all how she's going to behave when talking to other people. So there's nothing here that he can help me with, because it's like, yeah, sure, I'm sure she's fine when she's talking to her lawyer. That doesn't tell me how she behaved when she talked to all these people that she had romantic encounters with. Let's see. Gingras argues that she gets devastated by things like Dave Neal videos. I don't know what to tell her. Dave Neal videos are reactions to updates in the case. If there is new information, if there's a new filing, Dave will go make a video and cover it and give his commentary opinions. You can disagree with his opinions, or you can think maybe Dave got something wrong. He has an inaccuracy. The correct remedy for that is to explain what the problem is, not to silence Dave's videos just because they make you feel a certain way. If she thinks, or if her lawyer thinks, Dave Neal said something incorrect on purpose, like Dave lied, it is their responsibility to convince me by giving me a URL, a timestamp, a quote, the contrary evidence to that quote. And then, as step 2, that was step 1, step 2, prove it was a dishonest statement instead of something like, well, maybe he's just BSing around. Maybe he made an error. Maybe he's only stating his opinion or speculation. Maybe you have a misunderstanding of what you all are talking about. Proving a lie is very specific. You have to prove that the person knew the correct answer and they chose to say the incorrect answer in order to deceive someone. That's what a lie is. Making a mistake is not a lie. Having an opinion is not a lie. Misunderstanding or getting something wrong as an error is not a lie. Okay, so if you want to claim that Dave Neal videos have lies, you need to prove it. And I'm ready to examine it if you can complete these steps 1 and 2. But they haven't even completed step 1, a URL, a timestamp, a quote, and the contrary evidence to that quote. They haven't even done step 1, let alone step 2, and proving dishonesty. So you can make all the claims you want about Dave Neal videos or other videos. but you have to demonstrate it and prove it. Rachel Juarez brings up Laura's manipulative language in prior communications. She reads one of these emails. Gingras argues that most people have had bad behavior in their past and then they can grow and improve in the future. That's true. Reality Steve says, well, she's done this before multiple times, so why shouldn't I just assume she'll just keep doing this? Which is a fair point. If you're going to argue that people can grow and improve, you need to show that they are growing and improving. Because Reality Steve is just like, I'm going to make my prediction of future behavior based on past behavior unless you show me evidence of the change, the growth, and the improvement. Where is it? So Reality Steve asks for this. Rachel Juarez argues that manipulation, like date me or I'll have the babies instead of an abortion. If you date me, I'll get the abortion. Otherwise, I'm having the babies. This goes far beyond anything in a typical normal dating life. And so it's not just bad behavior. It goes beyond bad behavior. And, I don't think there's really a great answer for that. I think Gingras is basically saying, look, I want to look forward. I think people can improve. Hopefully, Laura's behavior improves. And so he has his hopes. And that's what we've got. Let's go on to the next section. All right, so they start talking about some of the next steps that might happen. Gingras argues something. He says something strange. He's like, you all won't let Laura end this. It's very weird. Because, of course, the next steps include 3 possible options. I guess there's 4 options, actually, that he and his client have. Okay, they can file a motion to reconsider with the appeals court. They can go to Arizona Supreme Court of Appeals. They can go to the U.S. Supreme Court of Appeals. And I guess the 4th option is they could pay the judgment. The problem is all of those actions are relying on them to take an action. Like, these are their options. I'm not forcing anybody to do any of these options. I think Gingras feels like other people are forcing him to do something because the judgment has been made. So there's an outstanding judgment. And I think he feels like that is action on someone else's part. It's not actually action. Like, nobody's doing anything. It's a standing judgment. It's done. In any case, Gingras argues that Laura feels like she's been treated unfairly. And again, okay, you can feel however you want. You can feel like you were abducted by aliens. I need proof. I need evidence and facts, not feelings. Gingras thinks it's fair for Clayton to also feel angry. Well, that's nice. Oh my gosh. Gingras thinks the whole case was just all about Woodnick getting revenge for the Laura Owens ex parte communication claims in the Greg Gillespie case, where she made very horrific claims against Woodnick and Greg Gillespie. And Gingras thinks that Woodnick is just doing this whole case to get revenge. Of course, he makes this claim with no evidence beyond his opinion or his feelings. So I don't know what to do with it except reject it because it's unconvincing. Gingras claims he wants everyone to leave each other alone. I think that's funny because it's it's a speech contradiction. In his prior video interview with Laura, he says, Laura, I would pay you to let me take this case to the U.S. Supreme Court. He's excited to try and get to the Supreme Court. But now today, in this Friday morning video, he's like, oh, everyone should just leave each other alone. The case should be dismissed. We should be done. These things don't match up. They don't match up. It's very confusing. Gingras claims that Laura claims that Dave Neal lied. And again, I said this before, and I'll just go over it again. Laura, David Gingras, if you're going to claim that Dave Neal lied, you have to give me a URL, a timestamp, a quote, the contrary evidence to the quote. And then, step 2, you have to prove dishonesty. You have to disambiguate the quote or the evidence in terms of a lie, some arbitrary bullshit, an error, an opinion, a misunderstanding. It's a 2-step process. You haven't even done step 1. Give me a break. They then have a conversation about Laura blogging. Gingras says she's blogging because she has to reply to things. She has to set the record straight. And it feels like he thinks people are just doing YouTube videos or writing stories out of thin air for no reason other than to harass his client. His argument about why his client is writing blogs to respond to things is exactly why everybody has coverage in this case. It's always a response to something. There's a new filing, there's a new Medium blog, there's new tweets on Twitter. There's something new that you want to talk about. Everything is a response. So it's a double standard for him to say that, people just need to shut up or stop talking about the case. But it's okay for his client to do it because she's responding to things. That's just a double standard. People responding to things and making videos, like I'm doing now, is normal dialogue. If someone thinks I say something in this video that they disagree with, they can add a comment. They can make their own video. They can send me an email. They can do whatever they want. We can have dialogue over time as the case progresses. This is just normal. And again, this case was brought to the public domain by his client, by Laura herself. Of course, people are going to talk about a public case. Anyway, Gingras argues that Clayton and Woodnick are keeping this going. The problem here is they're not taking any actions. There's an outstanding judgment. And yeah, if they get paid, they'll get paid. But that's not keeping it going by having an outstanding judgment. I don't know what he wants. It's almost like he wants them to receive this judgment from the court, this ruling that they're supposed to get paid. And then there's an appeal, and the appeal says, yeah, you should get paid. And then he thinks they should turn around and say, no, I don't want to get paid. I don't want to keep this going. Like, what is that? That doesn't make sense. It's absurd. The only actions that can happen moving forward are, for him and his client to decide. Do they want to file a motion to reconsider? Do they want to file an appeal with the Arizona Supreme Court? Do they want to file an appeal with the U.S. Supreme Court? Do they want to pay the bill? He says she can't pay the bill, but she could go get a job at a movie theater or Starbucks or something and start paying the bill. That would be the responsible adult thing to do. They have their options. Clayton and Woodnick don't have options. They either get paid or they don't get paid. They either respond to an appeal or there's no appeal to respond to. It's ridiculous. Anyway, let's go to the next section. This section is about Gingras being rude. Gingras agrees with Reality Steve that he comes across as a total asshole online, but not on the phone or in video chats one-on-one. Reality Steve has this sort of cognitive dissonance. He can't reconcile these two personas that Gingras appears to have. One where he's talking on the phone and he's very reasonable, and one where he's writing blogs or doing tweets and he's a total asshole. So this is what Reality Steve asks about. Gingras complains about things like this alleged flyer that was sent to Laura's gym and people allegedly laughing at body cam footage of a wellness check. And he doesn't like people doing these things. And, I certainly don't endorse anybody sending some sort of flyer, whatever this flyer is, to someone's gym. But I mean, if a person sent a flyer to Laura's gym, if a person laughed at something in an inappropriate way at a public body cam footage video, that is a problem with that person, that individual. The problem I have with David Gingras is that he doesn't say, I have a problem with the person who did this. He generalizes. He says, JFC sent a flyer to Laura's gym. JFC laughed at the body cam video. He says, these people are a cult. Like who? He generalizes and makes it unspecific and puts a label that has no scientific test. There's no scientific test I can do to find an arbitrary person on the street and determine if they are JFC or not. It's not like a blood type. It's not like a club where you have a membership card. It's not like AAA. I can go out on the street and ask someone if they belong to AAA or not. There's a scientific test you can do. There's no scientific test for JFC. Also, his pejorative use of the term cult is inaccurate. There's no cult. A cult is an organization that is consistent with something like the bite model of authoritarian control. There's no organization in this case, let alone an organization that is compliant with the bite model of authoritarian control. There's no cult. It's just more rhetoric, pejorative rhetoric, and generalizing in order to create a nebulous enemy, a cloud, an unspecified nebulous enemy that you can point to and attack as a straw man. That's my problem with this. Not that he's angry at someone who sent a flyer. Sure, fuck the person who sent a flyer. They're an asshole. They're a troll. They're an internet troll. They're not a cult. They're not JFC. It's a meaningless label. If you have a problem with someone who did something, take up your problem with them. Don't lump me or Reality Steve or Dave Neal or 100 other people who are just interested in watching this case in with the people you have a problem with and get angry and upset with, fly off the handle, and become a total asshole by your own admission. It's inappropriate, it's imprecise, it's undisciplined. He doesn't start off by being a good person and giving people the benefit of the doubt and having grace for others. Instead, what he does online, interacting with people, he demands people behave the way he wants, or he gets angry and blocks them, and then calls them Greg, calls them a cult, calls them JFC. This is reactive. It's conditional behavior. I will be nice to you if you are nice to me. This is manipulative. It's manipulation. This is not healthy. Psychologically, this is not healthy. In my opinion, he needs serious therapy to deal with this two-persona, total asshole problem that he has interacting with people on the internet. Let's go to the next section. All right, the discussion turns to more next steps. Gingras claims he wants the case to end. He argues that the parties should litigate further to get the open questions answered in the right forum rather than on social media. That's kind of weird. Like, he wants everything to be over, but he wants to go to the Supreme Court. He wants to have people sue each other to get answers. It's very strange. He argues that Clayton can just let it die. I don't know what that means. I mean, there's a judgment, and Clayton is just waiting to get paid. There's no, I don't know what let it die means. There's an open judgment. It's you either pay it or you don't. He doesn't explain how, given the decision to pursue appeals that are in his and his client's hands, not Clayton. Yeah. I mean, the next steps are really whether he and his client file more appeals. That's not up to Clayton. Very strange. And of course, Rachel and Reality Steve argue that Clayton is not doing anything. They make the same point. Gingras argues that Clayton is doing the judgment. So I guess he's saying maybe Clayton's trying to collect his judgment, and that's an action, which I guess is true. I don't understand why he thinks Clayton would want to stop trying to collect his judgment, though. I mean, if you go through a court case and you receive a judgment, you go through an appeal and you maintain your judgment, why would you just suddenly stop? It makes no sense. Rachel Juarez argues Laura should stop appealing and just say, hey, we're done appealing and there's no money for you to collect. Gingras' response to this is that Laura wants to redeem herself. I don't think she wants to redeem herself. I think she wants to get out of this case without a financial judgment against her. Here's the thing. These appeals are about matters of law. Like, did the case happen properly. If you win an appeal, you aren't changing any facts of the case. You aren't granting her redemption. Like, you're not proving that she was right. You would maybe be removing the financial judgment from her. That is not redemption. Redemption would be like admitting you couldn't prove your pregnancy or paternity properly after filing a case. You're very sorry you filed a case and then couldn't prove it properly and then pay your bill. This would be the adult responsible thing. I'm not even saying admit you weren't pregnant. I'm not even saying admit the paternity claim was wrong. I'm just saying admit you brought a case and failed to bring the appropriate level of evidence. Okay? That's not an admission of lying. It's just, I couldn't get the evidence into court and I failed and I admit it. And now I have to pay the bill. And as a responsible adult, that's what I'll do. That would be some redemption. Rachel Juarez argues David Gingras is admitting further action is because of Laura, not Clayton, with the appeals, because she wants to redeem herself. Gingras creates a hypothetical, again, another hypothetical that doesn't make sense. He makes a hypothetical related to Woodnick's offer to Lexi Linval to have Laura say she isn't pregnant. And of course, this hypothetical completely falls apart because here's the thing. If Woodnick says, look, Laura, if you were never pregnant and this was all just faking it, just say you were never pregnant, we'll go home. You know if you were pregnant or not. And if you weren't, just admit it and we'll all go home. That's an offer. Okay? Because she knows whether she was pregnant or not. And if she thinks she was pregnant, she can say no. No thanks. I'm not going to say something I don't agree with. That's fine. The problem with Gingras' example is his example says like, would Clayton sign something that says Laura was pregnant? The problem, Clayton can't know if Laura was pregnant or not. He can only start with the null hypothesis, which is human beings start out not pregnant. And then at some point, some human beings can become pregnant. And when they do, they can prove it with fetal heartbeat monitoring, ultrasounds, babies, clinical medical evidence of a miscarriage. In many cases, they can prove it. But it's not Clayton's pregnancy, so he can't know if she was. So his hypothetical situation is not the same because it's not about Clayton's information. It's about Laura's information. It's a non sequitur. It does not follow from reality. Okay. Gingras argues that Laura won't ever willingly admit to fraud. That's... I mean, she's admitted to fraud before. Why couldn't she do it again? I don't know. Anyway, Reality Steve asks, how can Laura's decision to appeal be described as Clayton continuing an action? Yeah, it's mental gymnastics. Gingras then blames Clayton's actions during the original court case. I mean, yeah, he asked for a judgment and got it, and now he's trying to collect on it. What a villain. This seems to be a you made me do this type of argument. Yeah, I mean, he's basically saying, oh no, Clayton responded to a court case that was brought against him, asked for fees, was awarded those fees, and is trying to collect those fees. Now we have to appeal because you made me do this. Like, the you made me do this argument, it reminds me of abusers. You know, Gingras is making an abuser's argument. You're making me appeal. If you hadn't done these terrible things first. Come on. This is the abuser's handbook. It's disgusting. Gingras, in discussing ways to end the case, eventually says, well, just tell Marcus to call me. And again, I don't know what he thinks Marcus is going to do. Marcus isn't the one trying to collect judgment, is he? Like, I don't, he's not going to, he doesn't have the authority to stop. What does he think Marcus is going to do? It's absurd. It's just very strange. It's very strange. Let's get to the end. Okay, so Reality Steve, after Rachel Juarez leaves, he asks Gingras to look at Laura's past behavior. He really says, look, I know you haven't investigated all this stuff from the past, but as a favor to me, go look at this stuff in events prior to him being on the case. And Gingras says, hey, look, if Laura has past bad behavior, maybe she needs help. We should be trying to help her. At the end, as they're wrapping up, it's very interesting. Gingras says he thinks that the county attorney, Rachel Mitchell, is gathering evidence with subpoenas related to the criminal investigation against Laura Owens. Now, at the end of his sentence, he kind of backs this off. He says, I assume, or something like this, a little caveat he throws in at the end. But I thought this was an interesting moment because this is kind of new information about the investigation, that the investigation is really ongoing. There's evidence gathering. There may be subpoenas being executed. And of course, last night, Dave Neal confirmed with his sources that the investigation is ongoing. So this does appear to be true. So thanks to Dave for figuring that out. Now, as they're having this discussion about the past actions, Gingras claims Laura's behavior really didn't hurt Mike Maricini because he never fought the protective order that she filed against him. And I think this is really minimizing. Mike was basically following his lawyer's advice. Maybe it wasn't great advice. He's a young guy. He's basically saying no contest. Okay. I don't agree with it, but I'm not going to fight it. Okay. I'm not admitting I'm guilty. It's just, this is easier than spending time, money, and resources to fight this whole thing. And he's a young guy, so he probably doesn't realize the implications at this point. Gingras claims that the paternity determination is all that the family court should have covered and does not agree that the family court should have had the broad discretion to look into all these things like past bad behavior. And of course, we saw the judge set the window back to 2020 in the February hearing. So he can disagree. He can say it's his opinion the judge shouldn't have done that, but it's objectively true that the judge did that. So I don't know what to tell him. He makes a comparison to civil law where they don't have as broad discretion in what they can do. Of course, this is family court. It's not civil court. He claims Rachel Juarez wouldn't agree if she was still there. It's reasonable because they've gone over it before. They're just rehashing this. And that's kind of the end with Reality Steve asking him to look at the past behavior and try to think about it a little bit and not minimize it. Okay? Because I think Reality Steve is approaching it from the point of view of, empathy and sympathy. And Gingras is really looking at it from the view of law, and that's it. Okay? So that's where they end things. Overall, when I look at this, there's themes that emerge. These are kind of my opinion conclusions. These are the things he does in this discussion when he gets backed into a corner or the discussion doesn't continue anymore. He'll say things like, that was before my time. We've heard that time and time again. He'll say, you and I just have different opinions. And again, it's not just you and me, it's you and everyone else. So when do we take a deeper look? Number 3, he's often saying something felt a certain way to him or his client. And again, feelings are not a valid pathway to truth in epistemology. I need facts and evidence, not feelings. We can talk about your feelings, but they're not going to get us to a place where we can agree on the critical issues of this paternity case. Okay, number 4, he often says things like, maybe something could have happened a certain way. It could be like this. Something could have happened like this. There's a lot of speculation. Again, I'm not interested in speculation. I don't care how it could have gone. I care about how it did go. Number 5, There are times when he'll make personal attacks, he'll make insults, or he'll be condescending. I think in this conversation, he didn't make, outrageous personal attacks or insults. I feel like he talked excessively. He was a bit condescending. Maybe he would interrupt. But we've seen in the past on Twitter, in blogs, he'll make personal attacks, he'll make insults, and then, he freely admits it. He admitted it to Reality Steve. He's admitted it to Omar, the tilted lawyer. It's a personality problem that he needs to work on. And then number 6, we've seen time and time again, he'll create these hypothetical examples that are either non sequiturs, they don't make any sense, or he'll leave conditions out, like the 4 corners example we went through earlier. And my problem is these 6 things. This is how he presents his PR, or this is how he presents his case, or his theory of the case, his timeline of the case, his arguments. He uses these tools. This is his toolbox. The problem is these things are not convincing to the broader audience, to people who are enthusiasts of science, chemistry, biology, logic, engineering. These things don't work. You need to abandon these crutches and focus on evidence and focus on high quality logical arguments and good evidence and good facts. And if you don't have those things, then you need to abandon your PR campaign and just write your motions as best you see them and leave it at that. Because going to YouTube and talking to Reality Steve, Rachel Juarez, whoever, having your own channel, and constantly using these 6 problematic methods of communication are not going to get you anywhere. So my advice is stop doing these 6 things. Start focusing on the facts. Start focusing on logic. Stop doing PR. Get rid of the rhetoric. And maybe you'll be more successful. In terms of final conclusions, I don't know. I think David Gingras needs to apologize for the personal attacks and insults he made against Dave Neal and Dave Neal's family. I think he needs to get a therapist and work through his issues of being a jerk online. And if he does those things, it will be a tremendous step forward for him, since he's a forward-looking guy and wants people to be better tomorrow compared to today. That's my advice. That's my assessment of this discussion. It was long, but very interesting. If you've stuck around this long, thanks for your time. I'm Bruce Morgan, Bruce the Moose. This is the Bruce Morgan Show. Have a good one.